Okay, I've had some requests from students that they like these recorded videos over the chapters, that they help them study. So I am going back and doing chapters 10 and 12. I think I already have 12 recorded, but I'm going to go back and record chapter 10 because that's going to be on the exam. And it's basically legal and ethical issues. You should have already studied that because you thought it was going to be on exam 2, but actually I'm going to put it on exam 3. So that gave you a little bit more study time. So we're just going to breeze through this. That way you can get an idea of what I'm looking for on the exam. Now, a lot of this stuff you covered in Nursing 101. So if I just kind of say, you need to review this, then go back and review that in nursing or from your Nursing 101 text. Otherwise, I'll try to elaborate on it as we go. So let's get going on chapter 10. Authority of ethical issues. Nurses are expected to adhere not only to ideas and norms of the profession. Whoops, sorry about the dog. Hang on. Okay, sorry about the dog. But anyways, nurses are expected to adhere to ideas and norms of a profession. We're also to embrace what it means to be a nurse. Results of ethical violations can result in disciplinary actions by the board, by your employer. You also may experience career jeopardizing distress from sacrificing personal and professional integrity. When we're talking about ethical principles, there's certain things, I think there's 5 or 7 ethical principles that we adhere to, or there's 6 actually. I knew there was close. But if we follow these ethical principles, the principles of autonomy, beneficence, non-malfeasance, justice, veracity, and fidelity, they're used to guide you in your practice. These principles reflect dignity of a person. Nurses may use these concepts to clarify what should be done in a situation, and they provide basic tools in approaching nursing ethical dilemmas. The chief one being the principle of autonomy, an individual's right to self-determination with freedom over one's affairs and self. This basically says I am my person until somebody deems me incompetent or unable to make a decision. People have the right to make those self-determinations. And we must respect that. We have to understand that it's the patient's right to decide not to have chemotherapy, or it's the patient's right not to have a feeding tube. We can't interfere in that self-determination. Then there's the principle of beneficence. This refers to a moral obligation to do good. Promoting good is typically defined as advancing the autonomous right of the individual. You demonstrate beneficence by acting on behalf of the patient, standing up and being that advocate and making sure that good is being done, or that what is good for the patient is being done. Then there's non-malfeasance, and this is basically that we are going to do no harm, that we make sure our actions are affirmative, our actions are evidence-based, our actions are appropriate, and that we do not go into a situation to do harm. Then there's the principle of justice. This is fair and equal treatment for others. And then the concept of veracity, the nurse's obligation to be truthful, transparent, forthcoming, and candid. This falls back into that therapeutic communication realm that we were talking about, where we were basically saying that, we have to be genuine with the patient, we have to have their best interest at heart, and we have to tell the truth. They look to us for truthfulness. Nursing has been found to be, for the last 16, 18, so many odd years, as the most truthful profession out there. And we want to continue that. And we do that through this ethical principle of veracity, that we have to be truthful, transparent, forthcoming, and candid. And then there is the one of fidelity, the nurse's obligation to be dedicated to the patient. We are the patient's advocate. We are all that they have. A nurse must demonstrate loyalty by practicing evidence-based practice, patient-centered care. And it's through veracity and fidelity that we build that nursing therapeutic relationship with the patient. Using these principles, we run into the thing called an ethical decision. This is a little bit different than making your decisions as far as the nurse-patient or the nursing process. This is when we have a decision or an ethical problem where there is basically no good answer. An ethical dilemma arises when you have a situation and either answer that you choose is not a good answer. Normally a bad outcome, comes out of it. For example, you have a situation where your two choices of treatment will either result in the patient's death or the patient being in a vegetative state. So, there's no good or right answer. It often involves a compromise or a balance, like I said, between those two unattractive alternatives. And we have to look at values, ideas that assign meaning to a decision, and integrity when we're looking at these. The ability to consistently adhere to character resonating values. So, we're looking at our values, our integrity, preserving compromises, account for conflicting alternatives, and assist nurse in resolving conflicts. Nurses understand professional and legal obligations. You have an integrity, you have, what you stand for. And, sometimes we have to have those compromises that preserve that. Nurses must assess, again, their own values, their own personal beliefs in order to better anticipate and manage these conflicts. Some things out there that can help you. Nurses should be familiar with the available ethical problem-solving resources because you are going to run upon these situations that happen. And some of these tools here can help you through those decision-making processes. There's the ANA Code of Ethics. If you're not familiar with that, you can look that up. That's the American Nurses Association. There is a link to the Code of Ethics. It has been updated within the last 2 years, I think, so you might want to read over that and see where our profession of nursing is coming from in regard to ethics. You can also contact your colleagues, supervisors, and mentors. What would you do in this situation? Help me with this decision. Be a sounding board, people to bounce ideas off of. The old saying, two minds are better than one. And then again, there's also the Hospital Ethics Committee. They're a neutral forum for discussion. Again, it's one of those places you can bounce ideas off of. Have two minds that are better than one. On this board, there's normally clinicians, administration, community, patient representatives. There's normally a wide variety of minds there that can help you say, here's the situation. Now, what do we think? What decisions are out there? And what can we do? When we're looking at ethical decision makings, there's an acronym pillar that we go by, and it's P, or the ability to appreciate how one's personal experiences, knowledge, and values accept the patient care. The I is the ability to identify the ethical issue. The L is the ability to appreciate and work within professional limitations. The other L is the ability to lessen the likelihood of future ethical dilemmas. The A is the ability to anticipate an ethical dilemma. And the R is the ability to access needed resources or informational expertise to help identify or clarify the concept. So if we're looking at ethical issues and we keep that in mind, we got to look at our personal experiences. We got to be able to identify the problem, look at, what limitations are we working within here, in the hospital, in the situation that we're in. When we make this decision, we want to have a basis that will lessen the likelihood of this dilemma happening again. You need to be able to anticipate these dilemmas and then look for those resources to help you make those decisions as we go along. On page 184 in your book on table 10.1, there is a guide for making ethical decision, and it follows the acronym dilemma. So that's another way that helps you make them. The D is to describe the conflict. The I is identify the stakeholders, who's involved. The L is learn the background information. The E is explore the options. The M is a moral hierarchy. The other M is make decisions, and another A is act and assess. So that's another thing, kind of like the nurse process. And it gives you questions and guidelines there that you can go through to make those ethical decisions. And you will use this in your practice. You'll run into it, on a monthly basis, if not even more, depending on the population that you work with. So let's look at some state and local laws, some other legal concerns that we need to be dealt with. When we're talking about mental health care is primarily affected by state law. It's not really affected by the federal. So most of your state laws oversee our mental health legalities and things out there. Another thing that guides what we do in mental health, of course, is that Nurse Practice Act. And I cannot stress the importance to anyone on reading the Nurse Practice Act. The Nurse Practice Act tells you legally what you can and cannot do, and you need to understand that and read that, or at least be able to know where to find it if a question arises as something that you can and cannot do. State laws affect the care of patients, of mental health, and the familiarity within them is important. So you have to, that's another thing we need. Especially if you're going to work with this population, you have to understand the state laws associated with it. However, there is some instances where federal laws, do come into play, and it's basically whether a state law violates a federal law or state laws may pre-exist federal laws. But for the most part, if the federal law is involved, it trumps whatever's going on in the state courts. And nurses must comply with both. Unfortunately, we got to know both of them out there. There's a lot of liability in working in mental health, just simply because of the nature of the beast. But some potential sources of liability that you might find in working with mental health, and actually in most aspects of nursing, are failure to assess that risk for suicide. You need to ask that question, and you're seeing that more and more in ER and in an acute care setting is, do you have feelings of hurting yourself or others? Simple question, and you've assessed that risk for suicide. Failure to monitor properly. If you don't visit that patient every 2 hours, or if you're not checking in on that patient and something happens in that time that you're not there, failure to properly monitor. Failure to communicate, document, or observe. If you don't communicate with your doctors, your other nurses on the floor, if you're not documenting appropriately, I know you hear of a saying, if it's not documented, it's not done. That's a way you can have some nursing liability issues. Failure to detect drug toxicity, that's that drug-to-drug interaction that you have to look at when you're giving medication. Failure to protect patients from other patients, a big one when you're working with the geriatric population and also the mental health population. If you know you have an aggressive behavior patient on the floor, and you also have somebody who's very meek and mild on the floor, and you leave them alone for any certain period of time, and the aggressive patient attacks the meek patient, that's your failure to protect that patient from other patients because you knew that was a volatile situation. Failure to provide just a safe environment, that puts you at liability. Failure to exercise correct care, that falls under malpractice and negligence, but however, again, it is a nursing liability. Nurses are liable for malpractice if she does not satisfy professional nursing standards. That's the difference between malpractice and negligence. If you remember, we have, if you're going, I think I've talked about this before, if not, you might have heard it in another class, but if you're going up in a lawsuit, you've been sued. Basically what they've done is they've taken that chart, they've sent it out to a nurse legal consultant, and the nurse legal consultant reads this chart, and she either comes back and says, yes, in this very same situation, I would have done the exact same thing or very similar to what this nurse done. She meets professional nursing standards. Then you did nothing wrong. However, if that nurse legal consultant comes back and says, well, she didn't do this, she didn't do this, I would have done this different, she did not meet federal nursing or satisfy professional nursing standards, that's malpractice. You did not practice to the ability of the professional nursing standards. You can be found guilty if you owed patient plaintiff care if you failed to meet those standards, patient to plaintiff suffered damages, or if there is a breach caused a foreseeable injury. Those are basically the four things you can be found if you're malpractice. If you owed them care and didn't provide it, if you failed to meet the standards, if they suffered damage because of your care, or the breach in care that you did not provide caused a foreseeable injury. That's malpractice. Patient safety. Duty of the nurses to prevent harm. Failure to monitor, document, communicate significant changes in the patient standards. Continuous regular monitoring of risk for patient standards or patient safety, a way that we can be found for malpractice. Suicide. Vigilant in assessing for suicide risk. It is one of those things that you need to ask for, and one of those things you need to keep in the back of your mind going on. Do I see things? Is there something iffy here? Something not quite right. But you need to be vigilant in assessing for that. Communicate your concerns to other members of the healthcare team and be aware of your agency policies and procedures concerning that. Medication errors. Not going to beat this dead dog you have in pharmacology right now, and you've also had medication administration 101, but you have to be diligent and vigilant in medication to prevent errors. Follow your 5 rights or your 6 rights depending on how they're broke down. Be knowledgeable about the medication you're administering. Watch for those side effects, so signs and symptoms of toxology and the mechanism of actions. And documentation. Again, you've had this, so we're just going to breeze through it. Essentials of communicating information among members of the team. It must be accurate, factual, and objective. I must be able to read your note and look and close my eyes and say, I can see that patient. It has to be that thorough. Notes should be written as if the patient may read them. Remember, we don't want to put anything in there that you don't want the patient to see, because they do have the right to look at that documentation if they so choose. Boundaries. Failure to maintain failure to maintain those boundaries jeopardizes the patient, and it also jeopardizes your integrity. So we have to keep those boundaries in check. It's a professional relationship, not a personal relationship. That's how come nurses should not take care of family, because when you do, you cross that boundary. So we have to keep those boundaries very, very professional. Remember, we've talked about self-disclosure, and I've beat it, this dead dog, not going to beat it no more. But some results from patients' inquiries, some is a voluntary offered. However, we have to be careful with what we disclose. Small talk is good. Disclosure of information that causes harm or causes the patient to concern or be worried, that's offering too much. And it can also result in issues if that patient is vulnerable. Good thing to ask. Do I have a need to tell, or does the patient have a need to know? Practice that and you should be in good form. Other forms of potential liability: violations of rights, assault, and battery. You'll see that in psych a lot, especially if you have a very combative patient. You want to watch out for that. Remember, when we're talking about assault, that's the threat. Battery is the actual action. False imprisonment, confinement of a patient against his or her will, including chemical and verbal intimidation. You can't restrain them. You can't put them in seclusion unless it is the absolute last resort on the list and you have documented everything possible up until that point. Defamation, libel, and slander, as well as invasion of privacy, are ways that we can have potential liable issues. Rights of patients, very, very important. Nurse advocacy for creation and protection of the rights that benefit those suffering from mental illness. Patients' rights are very important on the medical side. I'm not going to say they're not, but however, on the mental side, we're talking a box of TNT and a box of and the atom bomb. That's the difference. On the medical or the mental side, it is extremely important that we monitor those rights because they're right on the cusp of having their rights taken away from them, especially if they're on an involuntary hold or along that lines, which we'll talk about in just a minute. Because some symptoms interfere with the ability to know and enforce those rights. And again, it's almost exclusively state law that regulates these rights, and they do differ wildly from state to state. We want these patients to actively participate in care. Patients' rights to actively participate in self-determination falls under autonomy. It also falls under the Code of Ethics, as well as the Patient Self-Determination Act of 1991. It requires providers give patients written notice of all their rights, their right to refuse, with right to direct care and all that when they are admitted to the hospital. We do not have psychiatric advance directives per se in the state of Kentucky, but you can have them drawn up, and if you do present one to a mental health facility, they will honor it to the best of their ability because it is a form of way that the patient expresses their wishes. Advance directives, you know what those are. Legal documents that specifies health care or identifies a proxy, often addresses end-of-life care. That's exactly what a psychiatric advance directive is. It's specific to the incapacitation due to the mental illness. Again, not recognized in all states, but it does serve the same purpose. Informed consent. Vehicle by which patients exercises rights to self-determination. This is basically saying, I have been informed of what's going on, and I have self-determined, or I have gave my consent for this to happen. In order for this to happen, the patient has to have decision-making capacity. They have to have the adequate information, and it has to be a voluntary choice. There is a higher threshold of consent required for the procedure that has a significant risk. If there's any doubt at all whether a patient should be signing or not signing an informed consent, then it should be brought to the attention of a physician, doctor, supervisor, whoever is in charge of the patient. For informed consent, a person has to have capacity. And when we're talking about capacity, that's the clinical determination of whether a person or an individual has a capacity or the ability to make that healthcare decision. Are they cognizant? Are they alert and oriented ×3? Able to verbalize back to you in terms that they understand what procedure that they're going to do? Are they able to understand the consequences? The reasons that they're taking this treatment option? Are they able to understand the risks and the benefits? Are they able to verbalize back to you exactly what the physician's going to be doing? That means capacity. It can be fluid and specific to a time decision. The nurses are often the first one to decide whether this person has capacity. A doctor comes in and just says, I've talked to this patient, they've got this consent sign, da 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 da. And you're sitting there looking, okay, well, the last time I talked to this patient, they thought it was 1992, and they thought the president was Bill Clinton, but for a little specific time and space, they're pretty much alert and oriented. So, we're the first to bring that to the doctor's attention, say, hey, did you kind of notice, that this person's not quite right? So we have to make sure that, this is a understandable time, and it can change with decisions and specific times of days, but we have to make sure that we feel comfortable and that patient has the capacity to make that decision. No psychiatric or cognitive decision or condition automatically eliminates the presumption of capacity. Just because they're schizophrenic doesn't mean they do not have capacity, because remember that capacity is fluid and it's specific to time and decision. We might be able, it's not just because they have a disease that they cannot make these decisions. Ways that we can assess that if we need it in writing, of course, there's the mini mental status exam, and as well as aid to capacity evaluation, an ACE exam, and sometimes you will see those used. Competency, it's a little bit different than capacity. Adults are presumed to be competent. The only way they can be declared incompetent is through a hearing. and that's whether a patient has a mental disease or disorder, whether their judgment is impaired, or whether their mental disease or disorder significantly impairs that patient's ability to reason. So there's a difference between competency and capacity. Informed consent also requires disclosures. You all should have went through most of this in 101. The risks and benefits, the side effects, alternative treatments, all what's involved in informed consent varies from state to state, but it pretty much follows through. It has to be voluntary. There can be no coercion, no manipulation to get the person to sign, and obligation to identify a surrogate if the person is unable to make capacity or consent, and that's normally the next in line in kin or the healthcare proxy. Remember, let's talking about in 101 the nurse's role. It is not the nurse's role to give informed consent. It is the nurse's role to witness obtaining signatures for the informed consent. It is the physician's responsibility to approach and initiate that informed consent procedure. If for some reason that the patient is unable to sign, the nurse needs to document patient's lack of capacity and describe why. But remember, it is our responsibility to just basically witness and obtain signatures. Conferring with treatment team regarding concerns about the patient's capacity is another good way, like with those ethical decisions, to bounce those ideas off patients or off people and to see, what do you all think? What do you feel that's going on with this patient? Expectations or exceptions, to informed consent. This has come up in a couple of times in class. Life-threatening emergency. The patient is unconscious, unable to give consent, and in need of a life-saving intervention, and there is nobody else around to tell us what to do. Now, if you have a patient that is unconscious and you have a family member there saying da-da-da-da-da, you better follow what the family member says. This is in the event that a patient has a car accident, they're wheeled into your ER, there's absolutely nobody around, they're unconscious, and they've got to have this. And there's no documentation, nothing written, nothing came along with them that says they don't want any of this stuff. Informed consent is waived. Patient can waive deferring to the clinician. Prior patient knowledge and therapeutic knowledge, withholding information to prevent harm of the patient. Privacy and confidentiality is upheld foremost in the foreground, but the only time that you can waive privacy and confidentiality is in the act of duty to warn potential victims of foreseeable harm. It is the responsibility of a clinician to report if you feel that the patient is in danger of harming somebody else. When I get out of here, I'm going to go kill my counselor. It's your responsibility to report that. And it is also our responsibility to report suspected patient abuse. And if you have not done the mandatory reporting, which I see a lot of you all have not done, assignment on the web, then you need to make sure you get that done. Communication between nurse and patient is not privileged. You need to keep that in mind. The only privileged communication when we're dealing with privacy and confidentiality is between spouses, ministers and parishioners, attorney-client, and provider and patient. We are not providers as registered nurses, so we do not have that avenue for us. So let's talk a little bit about psychiatric hospitalizations. There's a stigma associated with them. People don't want to be in the hospital. They much less be in a psychiatric hospital. People automatically think they're crazy. We have to be very, very careful with our psychiatric hospitalization that the civil rights are not stripped. But however, some of their rights may be limited depending on the nature of the admission. There is different types of admissions. Let's breeze through those real quick. And they should be in your book starting on page 194. There's a voluntary admission. When a patient or someone on a patient's behalf makes a written application for consents to admission and treatment. This parallels admissions for non-psychiatric care. This is just like being admitted into the hospital. You voluntarily admit yourself into the mental health side of things. Then we have involuntary admissions. There's different ones. Police power. State hospitalized individuals who pose a danger to themselves or community. There's a parens parente power. The state hospitalized individuals who are unable to care for themselves. Accomplished with coercion despite being an action of compassion. And there's substantial infringement on freedoms. Involuntary admissions. These are admissions where people are put into the hospital, psychiatric hospital, who poses a danger to others or themselves, suicidal risk. They are unable to care for themselves, parens parente, and they're normally involuntary admitted using with some sort of coercion, despite this being an act of compassion, and that is okay. And there's also, you have to be careful because, again, there's substantial infringement on freedoms when we involuntarily admit somebody. And that's how come somebody cannot be voluntarily admitted for a long time. It is normally for 72 hours, and that is the end of that. We have to make sure that we follow due process. Individuals entitled to a meaningful opportunity to object, and we have to hear the objections. And they have to have adequate notice and hearing. To admit, must show that the individual poses a danger to self or others, suffers from a mental illness needing immediate treatment, or is gravely disabled. Those are the only 3 conditions that a person can be involuntarily admitted to a psych center for. The 3 types of involuntary hospitalizations: emergency, observational, and long-term involuntary admission, which is commitment, which is normally done through the courts. Commitment standards are controversial. They do vary. Different entities responsible for determining the criteria. It can be judicial, it could be medical, it could be administrative. Standards of proof must be sufficient to prevent an unlawful commitment. They must be clear and convincing evidence, and it must be beyond a reasonable doubt. Here's the 3 types I told you about: emergency hospitalization, immediate danger, observation or temporary. This is normally your 72-hour hold. And then the commitments for longer hospitalizations, which are normally your criminally intent and those type of things. With involuntary admissions, we have to be careful with those patients' rights. Which specific rights retained are determined by state law. And you need just to review Kentucky state law to understand that. But they're generally entitled to autonomy unless the court declares the patient incompetent. And they still can refuse treatment even though they're involuntarily admitted. When somebody becomes involuntarily admitted, the nurse must consult and follow state and facility policies. Right to treatment. The first recognized in the U.S. in 1971. It established conditions for adequate treatment. This is when we started looking at mental health and saying, these patients need to have some sort of legal ramifications that says, this is the way that we've got to treat these people. It's humane in a physiological and psychological environment. It has to be done by qualified staff with sufficient numbers, and there needs to be an individualized treatment plan. This is, before 1971, they were thrown in a mental institution where there might be 70 people and 2 people working. And they might be 2 people who had no qualifications at all. So, in 71, with this court battle with Wyatt versus Stickney, in 71, this is when we decided, hey, we've got to set some boundaries on how to take care of these people and what type of treatment that they're going to see. Rights outlined in the Wyatt lawsuit are not expressly affirmed. Right to treatment does not ensure needed treatment. It just ensures they're getting adequate treatment. They have the right to refuse that treatment. We already know that. Patients may reject needed treatments, even if they're hallucinatory and delusional, and they could be fear of side effects. Effective pharmacological treatment may reduce those symptoms and sometimes eliminate them, but they also have a negative impact on their cognition and volition. Justifications are offered before coercion. Emergency treatment can be done. Treatment in the patient's best interest is judged by a disinterested third-party person, and judicial determination of incompetence. So, you can administer medications to people if these 3 items here are met, even if the patient refuses. If it's an emergency situation, if the patient's life is in danger. If treatment is the patient's best interest, but that has to be judged by a third-party disinterested professional. Cannot be me, it cannot be the person treating it. You have to consult somebody totally independent and have them come in and say, yes, this treatment is needed by this person. It is in their best interest, even though they are refusing it. Or a judicial determination. So those are your 3 ways that we can involuntarily or voluntarily give somebody right medications even though they have refused them. Involuntary medication is permitted for fixed periods of time. Can't do it indefinitely. It's upon the commitment of the judicial system, and it's upon a separate authorizing judicial administrative hearing. Those, you have to have those in line. Before we do anything, we have to have a least restrictive setting in order to protect ourselves. Remember, we just cannot go straight to restraints and seclusions. We have to try the least restrictive before we advance into any of the right stripping treatments. There's issues with restraints. You know what those are: skin, nerve damage, respiratory distress, strangulation, and death. And nurses must document specific therapeutic basis for use, and that's just based on CMS, Joint Commission, the ANA, and as well as the APNA. Remember, this must be in the least restrictive setting. Restraints and seclusions must be time limited, discontinued when the patient's behavior is no longer there. And facilities strive to be restraint free. So that's the goal of everything. There's significant ethical and legal issues in looking at that right to least restrictive setting. That's why we have those outpatient treatment settings. Those are the least restrictive. Guideline for involuntary outpatient commitment in New York is Kendra's law. That's basically saying, we need to use the least restrictive, least right stripping treatment when taking care of these patients. Can we give them the same care in the community that they're getting in the hospital? And that way they're not in that restrictive environment. Rights to communications outside the hospital. Almost all patients are allowed to talk outside the hospital. It might be restricted times, however, but they do have those rights to talk with family members and that type of thing. Conversations with attorneys, families, and clergy must be private. We can't listen. And again, the telephone conversations and mailings are typically uncensored. When we're talking about patients involved in the criminal justice system, a little bit different. Misconception about the relationship between mental illness and crime. People suffering from mental illness often lack constant care, social support, and might prevent them from being involved with the criminal justice system. Correctional psychiatric nursing. We will be going to the prison later on, probably in April, and you'll get to see this kind of in action. But it's care to prison inmates, juvenile detention centers, substance abuse facilities. It addresses patients' mental health needs in a non-therapeutic environment, but they still have those mental health needs met. It's challenging because there's a lot of moral obligations as well as safety concerns. There's forensic psychiatric nursing within the partnership of the legal system. This normally serves pretrial functions by collecting evidence, providing assessment and expert testimony. Nurses must inform patients of lack of confidentiality when we're talking about this relationship, and there's also some guidelines to follow. To convict an individual of a crime, they must be mens rea, which is guilty state of mind. They can be actus rea, a guilty act, and there has to be a connection between the two. Society struggles with how mental illness falls in those three avenues. The 14th Amendment of the United States Constitution says that everybody has a right to due process, including competency to stand trial, assess patients' ability to reasonably consult with counsel, develop rational, factional understandings of nature of proceedings and punishment. The patient has to be able to, you have to be able to assess the patient's ability to do that. Can they consult with patient or the counsel, and can they understand what's going on with them? A lot of time nurses in the criminal justice system are used to evaluate competency, to evaluate the ability to stand trial. If a dependent is declared incompetent, they're moved to a locked psychiatric facility, and the goal at that time is to restore them to competency so they can stand trial. The idea of insanity is highly controversial and often misunderstood. It comes with the society's historical statement that only those capable of knowing, controlling their actions should be found culpable of wrongdoing, but not guilty by reason of insanity. Defendants involuntarily committed to a state treatment facility. When we're looking at this, the burden required for proof varies from state to state, and it's narrowing. The states are really looking at it and saying, you know, for a person to be found guilty by mental illness, the very, very narrow rules apply there, and you can look at those versus state by state. So that's it for Chapter 10. You might want to read over, complete Chapter 10, understand it. That way you know what's there. And if you have any questions, email me.